really delighted to see my all Bal Sakhas who were standing councils, both on direct and indirect tax. It was such a profound day for all of us. With my Lord's permission, we commence today's proceedings, and let us invoke the divine intervention of Ma Saraswati. Without much ado, we could play the Saraswati Vandana, please. May I request Rupali, Shivani, Radhika and Pratishtha to please honor the dignitaries on the dais. Please, very quickly, let's do this. Sir. Mr. Vora, no, I've been told by Dr. Bhasin, and that's a mandamus for me. Yeah. Mr. Banerjee. For many good things of my life, I've given the reins to Dr. Bhasin, whom I owe a lot in my life. If there is a terra firma, if at all there is, then it is all the credit goes to Dr. Bhasin. I request him to take this forward and shepherd today's program. I'm sure you know he needs no introduction. President of Society of Indian Law Firms and much accolades. Over to you, Dr. Bhasin.
Honorable Justice Ujjal Bhuiya, Judge Supreme Court of India, Honorable Justice Yashwant Verma, in absentia, although he'll be joining us very soon, Mr. R. Venkatramani, the Honorable Attorney General of India, Dr. Manoj Kumar, Honorable Additional Secretary, Ministry of Law and Justice, Government of India, Mr. Manoj Bhargav, Corporate Law Advisors, the publishers, and last but not the least, Dr. Aseem Chawla, my worthy colleagues, Mr. Gaurav Banerjee and Mr. Ajay Vora, and all other eminent members of the profession, ladies and gentlemen. When Aseem first approached me that he's releasing this book, so I said, "What is the topic?" So he gave me a topic and I misread it. I thought it is pain in the joints, not play in the joints. Because taxation we generally attribute, you see, to some pains for the citizens, and with the raids which go on, therefore it could be pain in the joints. But after reading the book, I completely changed my opinion that it is like a balm for the joints. And I think he's done a tremendous job, but it is not for the first time. He has been doing it with some publication known as Twists and Turns, and then the play in the joints, and so many other publications to his credit. I don't know how he churns them out. How does he get time, being the standing counsel for the department in the High Court? So, yeah. Mr. Judeja, welcome, please, sir. So I welcome you to this momentous occasion when this book is being released. And my personal experience with taxation only has been that I am a taxpayer. I am not a tax practitioner. I don't have any expertise in this field of law, which is a very, very highly specialized branch of law. And I think there are very few practitioners who have the ability to master this complex subject of taxation, which has various facets. Individuals are taxed, the corporates are taxed, then there are dimensions, you see, of global taxations, how all those issues arise. But I'm not an expert in any one of those. But I do get time with now 62 years of experience in the profession, sometimes to have a brush with taxation. But one pleasant brush I had was way back in 2003. Then to my surprise and amazement, I was given the Samman Patra for the honest taxpayer of the year. I think. So those are the celebrations which I have and remembrances so far as taxation is concerned. But I was very much interested in this particular publication, and I read it with great interest because I do have some multinational clients. Some of them do expect that their legal advisors would have some knowledge about the taxation issues. So I thought it is good to just go through that. And what I found was that there is an undercurrent running through the book of touching on issues that matter and doing so in a manner that is easy to understand. Moreover, Aseem brings to bear his considerable understanding of the realities of tax that only comes to some who have practiced tax law long enough to master it, but not so long as to become dated. His perspective is long and his outlook immediately relevant. His book is not only timely, it is evidence that we live in times where taxation has finally assumed its rightful place in the life of commerce in India. The book is captivating exploration of evolving landscapes of international taxation, cryptocurrency, goods and services tax, and beyond. With a blend of insightful analysis and engaging concepts, Aseem not only demystifies the complex tax implications, but also offers a forward-thinking perspective on the intersection of various spheres of current text trends having global resonance. The book is also inspirational to all international text practitioners. The author brings his personal experience and knowledge to analyze some of the most relevant text challenges. Although the context is mainly India, and this is important, the reflections contained in this work can be extrapolated to other latitudes. Also, his contribution goes beyond the technical aspects and explores potential text policy initiatives aimed at helping India to navigate its economic and social future towards prosperity. Aseem Chawla once again has delivered an impressive and elaborate work in which he addresses the vast array of topics of interest not only to Indian text practitioners and text scholars but also to international text lawyers who may benefit the valuable insights of the author on the relevant OECD topics addressed in the book. My deepest congratulations to Mr. Aseem Chawla. Thank you. I would now request the publisher of the book, Mr. Manoj Bhargav of the Corporate Law Advisors, very esteemed company dealing with the legal publications. So I request him to give your experience of dealing with Mr. Aseem Chawla and the contents of his book.
Thank you, sir. Honorable Justice Mr. Ujjwal Menon, Honorable Justice Mr. Yashwant Verma, Honorable Mr. R. Venkatramani, Dr. Lalit Bhasin, Dr. Manoj Kumar, Dr. Aseem Chawla, ladies and gentlemen. First of all, I would like to thank Mrs. Rupali Chawla for having invited me for this grand occasion and to share my experience as a publisher before this August gathering. Before I start sharing my experience, I would first like to share few statistics which would be of relevance. We started working on this book in the month of December 2023 with a target of completing it in around 2 to 3 months. It took us almost 10 to 11 months to complete it. We started with a target of around 200 pages, but the book ended with around 400 pages. Normally we finalize a book in around 2 or 3 proofs, but this book was finalized in around 6 proofs. During the course, the book has undergone around 2000 changes and alterations. When I was myself realizing from the statistics, what I realized was that I was actually working with a perfectionist. Dr. Chawla is a perfectionist in himself. Whatever he do, he would go beyond boundaries, but would not compromise. His perfection can also be summarized with one incident. Like after we finalized the book, we gave him the soft copy. We also gave him the printed format book in loosely format. He insisted that he be given proper finished books which he wanted to send to all the dignitaries. We said, this is not the industry norm. Why are you doing this? He said, this is how he gave respect to his seniors. He sent all the books in a printed format, proper book for all the forwards, for all the opinions and everything. During the journey of 10 months, Dr. Chawla was available 24/7. He encouraged us to call him and he was always available. The challenge for us was that he expected the same from us as well. While this is not, it was not easy for us. When we prepare a book of this sort, there are bound to be ups and downs. There are bound to be errors. There are bound to be confusions. But Dr. Chawla had always kept his patience. He had always been supportive. He had always been supported to his own staff, to our staff. This speaks about his humbleness. He's a thorough gentleman, I would say. He has his own style of working. Normally, we as publishers do not get involved in the contents. But Dr. Chawla always engaged us. In fact, he entangled us in the content part as well. Whenever there was some discussion, he would ask us to come prepared with the chapter so that he can discuss the corrections and the alterations in that. Last thing I would like to say about Dr. Chawla is that he is a genuine author. The contents of the book are genuine. They are 100% content, the genuine contents, I would say. I, as a publisher with over 35 years of experience in this line, it's hard to find authors like Dr. Chawla. I would like to conclude by saying that the journey had been memorable and satisfying, and I am extremely thankful to him to have increased our level of publication in this. I would also like to thank Mr. Sanjay Sethi, who had been a common friend and who introduced me to Dr. Chawla. He played a vital role in making of this book. I would once again like to thank Dr. Chawla for reposing his confidence on us and giving this opportunity. And I thank you all for your patient listening. Thank you.
Thank you, Mr. Bhargav. You said that you found that Mr. Aseem Chawla is a genuine author. So you mean there are other fake authors also in the field of law? I have not. Yeah. But it is a big product, you see, what he has produced. As they say, behind every successful man there is a woman, but I say no. Here there is a family behind him. His father, his wife, the entire family is here, his brothers, they are all here in full force. They are a source of big support, you see, for bringing out such a excellent publication, and thanks to you as a publisher. It is now my privilege to invite someone who has been one of us for the duration of his tenure as a legal professional, heading one of the topmost law firms, and now he has the distinction of being shifted laterally to the Ministry of Law and Justice as the additional secretary. I'm speaking about Dr. Manoj Kumar, and he's the additional secretary in the Ministry of Law and Justice, legislative wing, which I believe definitely you require people like him so far as legislations are concerned, because as our Supreme Court has said repeatedly, some of our, sir, with due permission, that our laws are ill-drafted. So I hope now some expertise will come in and we'll have good laws, simple laws, easily understandable laws with your experience. So I have great pleasure in inviting you.
Honorable Justice Sujal Bhuiya, respected Sri R. Venkatramani ji, Attorney General for India, Honorable Justice Yashwant Verma, I believe is on his way, respected Dr. Lalit Bhasin, Shri Manoj Bhargav, Managing Director, Corporate Law Advisors, and of course my friend, dear friend, Aseem. In fact, sir, before I get into this speech, 2 points. One, of course, the motivation to take up an assignment in government and to relinquish practice, amongst such a grand luminary of galaxy of luminaries that we have, comes from inspirations like our learned Attorney General, Shri R. Venkatramani and Dr. Lalit Bhasin. And of course, the laws need to improve, the legislation process needs to improve, and of course, we'll be doing our best for that. Aseem came with a book, as Manuji was mentioning. It was a draft version, I believe, just pre-publication, to have a look, and he asked for my remarks, and I was astonished to see the monumental effort that he had put in and the contribution that he has made. The entire perspective of analyzing the tax laws and the judgments and the journey of the court pronouncements and the legislative process in a very different flavor. It almost looks like a journey which will continue, and will very shortly need to have subsequent editions of add-ons of this book in times to come. Well, I've been requested to speak on a topic, contemporary legislative outlook in an ever-evolving ecosystem. This is a moment to celebrate the monumental work, but I'll try and keep the discussion light and not very mundane. In the contemporary outlook on the legislative process or the legislative drafting process, primarily, if I can just put a certain direction to the discussion, the guiding principle is minimum government and maximum governance. What do we mean by that? What is the change that the contemporary outlook seeks to achieve? The contemporary outlook seeks to achieve simplification of laws. So the existing laws that we have, the new laws that are to be prepared in a very simple manner, use of plain language. And of course, when we do this transformation, the skill set of the people or the workforce who has been drafting laws for many decades now also requires to be skilled up. So a lot of capacity building exercise, essentially from the style of drafting, as well as a plethora of new areas where legislative work needs to be done. The other very important aspect of the changes in the legislative outlook is to have a deeper engagement with the citizens while the law is being prepared. Dr. Bhasin was very kindly mentioning that the quality of laws have been remarked on by courts and also by our fellow colleagues at the bar and other stakeholders. The legislative process involves a certain window for public consultation, and I did mention this a few days ago when we had met in another discussion like this, that professionals like ourselves, the legal community, needs to be far more engaging and make use of every opportunity of public consultation when a draft law is put out there for 30 days for inputs from stakeholders. As lawyers, we are stakeholders in all sectors. It doesn't have to be only about the legal profession or the judicial system. For example, the consultation paper on arbitration law is out, as we are all aware, and all the time we keep hearing about the quality of law on the arbitration side. An effort has been made to tick the box on every possible input, right from the committees set up by the government to expert opinions and so on and so forth. Now, that kind of a monumental effort has gone into preparing that tabular document, for which we need further streamlining and inputs. So it will be of a great contribution by each of us in the bar to spare some time, not only the arbitration law, whenever similar draft laws are put up there for consultation, public consultation, to make use of every such opportunity to give our inputs while the law is being made. Therefore, in the legislative outlook, the contemporary outlook, citizens' ability to participate, of course, lawyers definitely, but even other stakeholders who may not be practicing law. How do we create processes where we get deeper engagement with the citizens? And one very important aspect which we need to push is a completely unfettered access to laws after the laws are made. The legislative process should be such that the law should be in simple language And also it should be made available to the last person who may not be required to go to a lawyer to find out what do I do when something has happened. So that entire authenticated repository of law should be available to everybody in their palm top, if I may say so. To achieve some of these contemporary objectives, how do we get about doing things? Well, technology is something which has taken over us over the last decade or so in ways that we had never imagined. It has impacted all sectors. Legislative process is also not untouched. And in fact, there are a complete string of advantages that technology can help and to achieve some of these objectives that we're talking about. For long, legislative process has been a labor intensive. The manual drafting, even in the legal side, we used to drafting by hand and then typing and cyclo-styling. Those of us who have spent 20, 30, 35 years in the profession would have seen those days in the Supreme Court when multiple sets were made out of cyclo-styles. So from that, the entire journey has changed a lot on the law practice side. On the legislative side, also that journey needs to be changed, and technology is helping us in that. From the stage of initiation of a proposal or a thought for a new law or a change in law, the entire journey involves, it's all available as a matter of public procedure. On the lawmaking side, interdepartmental coordinations, legislative drafting, legislative research, public consultations, as I mentioned, and navigating through the legislative process till it becomes a law, and ultimately the law gets notified and published in the Gazette. This entire process has a deep interplay of technology now, essentially to ensure that there's consistency in the process. There is an ease of access in legal research, so that similar legislations globally or even within India, even within our legislative system, different laws can speak to each other. We don't have different same terms or same principles being applied differently in different legislations. And of course, public consultation can happen more effectively by people just going to the website and giving their inputs virtually online. Therefore, citizen contribution in the lawmaking process is being helped a lot. Capacity building, again, the training of the lawmakers, the training of the people who want to contribute. As a citizen, you don't have to have a LLB degree to contribute. If you know your sector well, you just need a little bit of skilling up on how to write that input that you want to give. Everything is available online. Therefore, capacity building is now being available at the desk of anybody who wants to take the training, more so in this particular case, the legislative draft persons. Transparency and open governance is the underlying flow of the contemporary outlook, and access to laws to every citizen, as I mentioned earlier. The other very important area that a repository of law can provide is creating a digital public infrastructure where service providers who are offering services, legal solutions, can plug in to an authenticated resource. It is already available. It is not something that we're talking about, but in the contemporary context, it is something which has been achieved, called India Code. I mean, that's an authenticated resource available to every citizen for the right version of the law. And every service provider who is providing services to any citizen through an app or through a software in terms of making various legal documents, providing direction to where to go for legal solutions, Motor Vehicles Act, or so on and so forth. It's a plug-in that is being relied upon. The next thing in futuristic terms in the contemporary outlook is how deeply we can engage with artificial intelligence in automating the legislative process. It's an area that is, of course, under study, just like all other departments and ministries. This is an area to watch out for. We should all together align ourselves when we get into public consultations on how deep artificial intelligence can impact the lawmaking process. I think with this, through a responsible use of technology, we're building a legislative process that not only upholds our values, but also meets the needs of the new era. We are setting the stage for a legislative process that is responsive, inclusive, progressive, ultimately making Bharat a stronger and more resilient democracy. Thank you so much for this opportunity, Rupali and Aseem, and many congratulations to you.
Thank you, Dr. Manoj Kumar. I'll be remiss if we don't recognize the presence of my Lord Justice Dudeja here. If I can request Mr. Siali, I learned my law at his feet. If you could just felicitate Justice Dudeja, please. And then I'll request Mr. Satyan Sethi because we have tax is not a child of lesser God. We have Mr. Mohit Mathur, our President of Delhi High Court Bar Association. We have Mr. Gaurav Banerjee, President of Arbitration Bar of India, which itself does epitomize that we are a vertical, but we are seen in court every day. Why don't you just come and felicitate Mr. Sethi, please felicitate Mr. Mathur. Sumit, can you come and just give a bouquet to Mr. Banerjee, please? Thank you, Mohit sir. Your presence means a lot to all of us who do come court every day, but still are not regarded as mainstream lawyers. I don't know why. Yeah. Thank you, Mr. Banerjee. Your presence means a lot in many ways, and yeah, thank you for this. Back to Dr. Bhasin. Thank you.
Thank you. Thank you, Aseem. Thank you, Dr. Manoj Kumar. My only request to you is, since you are in the legislative department of the Ministry of Law and Justice, and this is on a serious note, how to make the taxation process more citizen friendly rather than the coercive method which is prevalent these days. Let citizens, that awareness be created in the citizens, that it is in their interest if they are honest taxpayers. But I think resort to coercive method should be the last one. I think I'm very happy to see that Honorable Judge of the Supreme Court is nodding his head in agreement. So hopefully it will come as an order sometime. So thank you very much, Dr. Manoj Kumar. And now the next speaker, the keynote speech is by Mr. R. Venkatramani. Not yet, sir. Out of 44 years of his law practice, I have had the privilege of knowing him for at least 25 to 30 years. I have not known him as the Attorney General because he was not the Attorney General. I did not even know him when he was elevated as a senior advocate. I have known him even prior to that as a jurist par excellence, as an academician who virtually devoted so much of time visiting the law schools, guiding them, not only just in having some moot competition, but to create awareness in them about the constitutional values and the ethos of our profession and the contribution our profession has made. He is, if one can call, all in one. Besides his legal acumen in the courts, he is of course a star performer. That is why he has been rightly elevated as the Attorney General of India, the only constitutional post in our constitution recognizing the legal profession. So it is an honor to our profession that we have a person like Mr. Venkatramani, you see, as the Attorney General of India, and it is my privilege to request him to give his keynote address.
Let me first appreciate the wonderful work done by Mr. Chawla, who is the chief guest of the day. An author is always the chief guest of the day. We are all only invitees. And the importance of a book launch, I always find, is that it's not only the author carries a lot of moments of importance, self-fulfillment, having worked for a long time, gestation periods, uncertainties and things like that. But when people gather on occasions like this, it means we are part of sharing the importance of generation of ideas. Writing is about generation of ideas. And we also then underscore that by writing, we see the further importance of sharing. So writing and sharing, I think, are twin elements of a book launch. And gatherings like this, I suppose, is certification enough to show that Aseem has earned well today. And he will continue to earn much more, probably then as more people, not only publishers, but government and courts began to look at him for more creative and committed assistance and involvement. When he asked me to write a small note about the book, I told him I am like just Mr. Bhasin. I am also a very honest taxpayer waiting for my Samman Patra, but I am not a taxation expert. Even though one of my subjects, 3-year law school, good old days, you have your optional subjects. Like taxation was my optional subject, but as I moved into Supreme Court practice in the initial days, it was a different occupation. But though I did do some tax practice, indirect tax practice, but this is a different genre. And I said probably I am not qualified enough to even share my reflections on his wonderful writings, which range from domestic to international spectrum. And then I thought, let me only reflect on what an able writer can do. That's not what I've said in the book. Beyond that, I don't think I'm qualified to say anything. But then he asked me to come and talk today about administration of justice and duties of the state. I was lost in the sea. I mean, there's a subject as good as writing about global constitutionalism. It's as good as modern global trade and commerce and tax practice. Double taxation, my God, where am I going? I thought, let me be on terra firma and talk something very close, probably one can understand. So I thank Aseem for inviting me today, and my grateful regards and warm welcome to Judicial Boyan, whom I regard very highly. And I am also partly responsible for Manoj to be getting into the, to the civil service. I don't think we should use the bureaucracy. It's a very outmoded word. Civil service connects a whole range of connotations. People who are civilian enough to serve the nation and the people of the country. So when we had thoughts about the way of drafting legislation, I took a survey before I come to the subject. I took a survey after I became an Attorney General of how legislations are being drafted across the world. And when Mr. Bhasin says very, very clumsy legislation, something like that, or very difficult to comprehend, the first piece of legislation I took to read was the income tax in England. I think our income tax law fares very, very, very better compared to the income tax law of England. So I look at many legislations in different parts of the world. So I thought it's important that India should have a dedicated legislative drafting wing where people who have experience in the profession can be drawn into the service. So your proposal is mooted that a lateral entry should be made available, and I was part of the interview team which selected Mr. Manoj, and I'm too happy that both of us are working together on many probably initiatives which would probably fleece Mr. Bhasin's ears very soon on how the legislative exercise in the Indian central government level. And soon, probably while this is on, state governments would like to catch up with examples like this. So I'm glad to say that things are moving at a fairly good space. Now we want to talk about administration of justice and duties of the state, one's mind goes back to the Roman period. In the Roman period, I think the law was feared most. People fear the law most, then they look at it as a matter of protection. So when it became possible for people to look at law not as a fearsome phenomena, but as a protective phenomena. So from a fearsome, coercive phenomena, when can law really become a protective phenomena? This transition could have happened and could not have happened, perhaps, without the idea of a constitution, emerging in the human psyche all over the globe over a period of time. And if you go back to even in a pre-constitution days in our own country, Arthashastra talked about 7 or 8 important qualifications for a governance. And it looked at a coercive state with a non-coercive state. You go back to John Stuart Mill, any of the Western European writings on political state and theory of state, etc., ending somewhere in Marxist understanding of state, you find a lot of thoughts about coercive state and non-coercive state. And I thought the end of politics would be, as the Western writer talked about, the end of politics would be the state withering away and coercion, I think, of course, disappearing. But that's a great dream. I mean, before we can reach that kind of an utopia, when the state will exist at the most minimal level, and how do we really talk about that? But I think it's important for us to connect the taxation field, where many of us think, as Aseem talked about, the pain, the joins. I don't think whether we can ever talk about taxation in the contemporary world as a pain phenomena at all. I'm not talking about how the system works. I'm looking at the principles and ideas. Now, in any economics is closer to the understanding of the demand and supply principle. Now, in a society, in order that state can make a demand, there must be something from which demand can be made. So, without a source from which demand can be made, obviously there cannot be a supply. So, this demand and supply, if you apply to the field of taxation, I think we really get into the core of economics of a free economic and a free economic order. So, how do we really fix this demand and supply and a free economic order? I would probably look at it like this, and picking up some ideas from how contemporary political writers and thinkers are looking at it. Now, for any country today, we are no longer an island, an isolated island, and we are no longer a country like any other country could conceive and work about realizing constitutional values by working within domestic frontiers. And as one of the English poets, John Donne, said, no man is an island. No country can be an island or an isolated oasis today. If that is so, we are so globally connected in myriad ways, which we did not conceive, probably even a decade or two ago. So the global connectedness in many ways has also probably led to even political thinkers and legal scholars and looking at administration of justice and the duties of the state from very, very different angles. So probably we can look at 2 components. One is that every country has what we call the inherited determinants of a past history, things like that. I'll come to that a little later. Then the human capital determinants. So in order that a country, and the most able and the wise and the mature way, a country can manage, organize very creative relationship between the inherited determinants which the country inherits at any given point of time. And welcome Jashwant Verma. So I'm pleased to be. Please join us here. So as wise and mature, as any country can manage the inherited determinants and the human capital determinants. And what do you mean by the inherited determinants? Probably one can look at the geography of a country, its geology, its genealogy, that is our history, etc., and acts of nature which a country is exposed to. So one may call them as the inherited determinants of a country. You cannot bargain with them. They are determinants which you have to work with. And then we also have, before I go into some details of it, we also have what one may call the human capital determinants. The human capital determinants have probably the connections today, contemporary countries, the connection today between how every one of us feel that I'm able to innovate, create, and produce by individually or otherwise by a collective, wide range of wealth and resources for a community. And that's a human capital determinant. And as long as the human capital determinants are free, I think a country would be probably in a position to rise in the index of its ability to manage its inherited determinants. If you're not able to really give sufficient room and adequate room for the capital determinants, human capital determinants to be free enough to generate a wide range of resources, then I think you will be failing in your capacity to deal with the inherited determinants. That's a very important connection. So, if the human capital determinants and how, to what extent, in what manner, legislations, ideas, principles, policies deal with them, and able to provide a certain sense of comfort and the fundamental feeling that I said that every one of us want to be able to be creators of whatever wealth and resources we would like to conceive of. So that, I think, is one of the most fundamental duty of the state today. If I am a believer in a doctrine or Marxism, I would have said at some good point of time after the dictatorship of the proletariat would have led to a great global, golden age, the state would have withered away on its own. But I don't think that great dream of building a global socialist framework could itself withered away for a number of reasons. So after the what one may call the withering away of the Eastern European socialist experiments and elsewhere, now we realize, not only by reason of wide range of human rights declarations, conventions, etc., I think globally we have realized, and within every country and otherwise, that liberty, freedom to think, innovate and create, I think is a non-negotiable fundamental of a civilizational order. And where this ability and the freedom to innovate and create and think, when you talk of an asset, it's not merely a table and a chair and a land and or a water. We're talking of an asset today in a wide range of circumstances and comprehension. So anything that human beings individually and collectively would be in a position to create is an asset. My idea is an asset, therefore it is a patent is an asset because it's an idea. Intellectual properties are based in the understanding. Therefore, globally today, I don't think any state, any country can probably bargain with the question, the importance of individuals' liberty and freedom to create and innovate. So that is a human capital determinant. On the human capital determinant, now what will be probably an ideal way? While we talk about an ideal way, we know that whenever legislations are made, we look at the ideal way of getting things done through a particular law. But when the matter comes to the court, the ideal way sometimes flounder. So, but what is important is as much as the human capital determinants are surveyed, valued, and their importance underscored in every policy measure that the government would like to contemplate, I think the first and foremost duty of a contemporary state gets discharged. Once that gets discharged, then there comes the question of clarity in how you go about discharging that exercise. The clarity, of course, is sometimes get lost in the means to be achieved, and there we get again into problems of building up new institutions in substitution of old institutions. Our existing institutions of governance and civil structure are still to a large extent founded on the English models. And the gap between the people's participation and their ability to, today we have a large number of people, young people, studying engineering, medicine, any of the disciplines of knowledge today we have. The venture they're able to enter into and the kind of support and what one would like to have a support system from the government, I think still there is find a little gap. How do we really bridge this gap? The institutional structures we have today in governance, I think, are lacking in this regard. Probably, as we move further in the exercises with Manoj Kumar and we are all, we would probably look at how to bridge the gap between, or probably think about conceiving new institutional structures which are becoming more responsible and are available for people to negotiate a bargain gap between I suppose I want to sell an idea to the government. I need to go through a large range of processes and procedures. My ideas cannot be sold so easily. And when I say my idea to be sold, not necessarily for a price, I want to share my idea. Who will get the reception of an idea? In what manner can it be received and quickly transmitted into a practice? So there is, I think, good deal of institutional reforms are required. So in the context of human capital determinants, I'd probably think of large-scale institutional changes at the governance level, which will probably facilitate and enable the human capital determinants to flourish. And when you talk of the human capital determinants, probably one can think of about 6 to 7 components. Let me quickly look at them. All of us, I think, been told that it is too bad to be selfish. But if I want to innovate and create, I would like to look at my self-interest of being able to have a time, the resources, the capacity, the freedom, and the support. Therefore, self-interest in creating is going to be, nobody could have conceived an artificial intelligence or the innovations in technology without somebody wanting to be involved in promoting something. And that self-interest is not what called ignoble self-interest. We are not talking about the base selfishness, etc. Then we also look at the way to drive to gain and keep wealth and power. That's where taxation comes somewhere, directly or indirectly. But the drive to keep wealth and power, insofar as that further leads to what I called initially the demand and supply component. If the drive to gain and keep wealth and power are components of enabling people to generate more and more, and therefore be in a position of creating more demand and be able to have less supply or more supply, as the case may be. Then today the capital markets have undergone tremendous changes. They are no longer isolated markets within a domestic frontier. The capital markets, like an idea flourishing across the globe, have also undertaken new wings, and they know no borders, and the kind of new ventures which were able to imagine, conceive, and put into practice were all part of a capital markets, unlike what Adam Smith would have talked about it long years ago. Then we have the big multi-generational psychological cycle. Now, another 10 or 15 years later, I think all of us would have looked at the world very differently. For those of us who are great sufficiently enough, the world would be little more less comprehensible. And for those who are yet in the early teens, 25 years, I think the world would look very, very different, going to be very different. Not merely the way we will be transacting our transactions, but even the physical part of the world may undergo a tremendous amount of changes. So if I was reading the other day a book on law in the times of called modern machines. So another 25 years you can sit at home and on a touch of button get everything about life done. And so in that, if you are to leap into that kind of future, and in that future, like many utopian writers would like to write now, if you go and look at that kind of a future, what will be the duty of the state today to ensure that our fundamental freedoms, I said the liberty to create, to innovate, I think the end of civilization, the means towards civilization will ultimately that each one of us will cherish this important value. I think that is going to be forever a non-negotiable duty of the state. So I can probably talk about many of those connections, but I thought let me just flag some of them. And for a tax lawyer, I think you must start looking at them from more than one conventional angle. As many resources from where taxes can be generated, and as many possible, even non-coercive, less intrusive means through which tax demands and supplies can be accomplished, I think that's going to be your job. And that's going to be your job to enable the duties of the state to be discharged less and less coercively. And then who would not like to have the state not standing behind me and say watching whatever I am trying to do? I try to conclude by saying that long ago, George Orwell, when he wrote the book 1984, he was talking about a thought machine. Sometime later, he thought in future we would have invented a thought machine. Any part of this room, I do not know if it is available today, any part of the room there can be a thought machine which can read my thoughts. And then I do not know, my thoughts are so open to somebody knocking out of my head. So that thought machine probably is going to happen very soon in diverse ways. When that is going to happen, what will be the duty of the state is what we are trying to talk about. But more importantly, in the context of publication like taxation law, how are you going to look at that? Too many subjects and very interesting, exciting areas of avenue of discussion and debate. Let me once again thank Aseem for calling me today, and thank you for your attention.
We have before I request Dr. Bhasin for his interventions on subject, we have Justice Verma in our midst. We are so grateful. May I request Rupali to please do the honors very quickly, and let's welcome Honorable Justice Verma, sir. Once again, over to Dr. Bhasin.
In law, we have indirect evidence and then direct evidence. When I told you that Mr. Venkat Ramani is a jurist, or he's an academician, or he's a brilliant lawyer, a brilliant law officer, it was just my saying it, you see. It was indirect evidence. But now you have had the direct evidence, which proves, you see, that Mr. Venkat Ramani is all in one, and soon possibly he may be authoring a book on taxation. Although he said that he does not have expertise in taxation, I genuinely feel I don't have any expertise, much knowledge, but I'm sure that he'll come out with a book how to familiarize citizens with the implications of taxation, or possibly how not to have taxation at all. But that won't be good for income tax practitioners, you know. Anyway, so it's now my great pleasure and privilege to request our Honorable Justice Yashwant Verma of Delhi High Court to be the next speaker. Justice Verma has been a judge of Allahabad High Court for nearly 7-8 years, from 2014 till 2021. And during his tenure in Allahabad and in Delhi High Court, he has presided over and delivered judgments on varied subjects such as constitutional law, arbitration, intellectual property, commercial disputes, direct and indirect taxation, white-collar legislation, and a host of other subjects. Presently, he heads the Division Bench of High Court of Delhi, dealing with taxation matters and the arising out of even the appellate authorities. It's a great privilege for us to have the presence, a gracious presence of Honorable Justice Verma. I request him to please give the words of encouragement to the author and to speak about him and the book.
Good evening. My apologies for being late. I couldn't agree with Dr. Bhasin more when he spoke of Mr. Venkat Ramani, our esteemed Attorney General. And thank God I have to make no cerebral comments after you all have seen the breadth of his erudition, his wisdom, on the subjects that he spoke of. Though many of you here today have had the privilege of knowing Aseem for years now, I had the good fortune of being introduced to him when I presided over the taxing roster on of the Delhi High Court. Speaking from personal experience, I have no hesitation in saying that it was always a pleasure to hear Aseem. He never failed to impress and always came across as someone who strives for perfection and is meticulously precise in his work, and he expects the same from you, unfortunately. His love for the law is infectious and is reflected in the work that he does. Aseem brings with him decades of experience in which he has managed to establish himself as one of the leading voices in matters relating to international tax, cross-border tax issues, business advisory, exchange control, regulation, money laundering laws. The sincerity that he exhibits as an advocate also infuses in his work as an author. Well, he already has notable authorships under his belt, starting from Finding a Straight Line Between Twists and Turns, which has rightfully received accolades from all quarters. His most recently curated Supreme Court on Company Law, in 3 volumes published by Bloomsbury, which was yet another example of an outstanding display of his knowledge and erudition. His versatility across various different fields of law shines through, as evidenced by his sagacious interpretation and understanding of the law across his publications. I consider his contributions to taxation of crypto assets, which was published by Kluwer's Law International, and analysis of tax treaty disputes, which was published by Cambridge, being just some of his examples of impressive work of writing. It is thus with immense pleasure that I stand in your midst to support his newest book launch, Plain Joints, an invaluable contribution to the field as it deals with complex legal issues such as significant economic presence, and deftly maneuvers through themes of nexus theory, intangible business connection, and India's continued quest to expand boundaries of source-based taxation, and something which he advocates pretty often. Aseem's astute observations on the BEPS action plan and his quest for finding a concrete resolution between the principle of source and residence will surely guide the discussion in the days ahead. Equally illuminating is his exploration of the MFN clause and its interplay with global economic policy. He succinctly captures the tussle that arises between national sovereignty and international cooperation. His take on its interpretation and how that would have to be read with the standards of multilateral organizations and what it stands for today in light of Nestle was distinctly compelling and gives us food for thought. His breakdown on digitalization has had an unprecedented impact on existing tax principles and on the conventional concept of physical trade being supplanted by the digital economy is a discussion which is of utmost significance in today's changing times. His suggestion that India abolish all unilateral measures such as special economic presence in order to successfully implement the two-pillar approach is again compelling, and I'm sure it would give a lot of lawyers and policymakers alike some nightmares. I'm confident, Aseem, that your brilliant analysis of all these issues will serve as an extremely useful guide to legal practitioners, policymakers alike. Your remarkable understanding of the law has become a hallmark of your own character. and I'm sure that this extraordinary achievement would constitute yet another feather in your cap. Knowing Aseem, I'm confident that he will not rest easy, and will in the years ahead inspire the journey of many of the young tax practitioners who are in our midst today, and continue to provide invaluable assistance to judges and lawyers alike. May you continue to challenge our understanding of the law. Thank you.
No, Justice Verma, you were not late, because I know it for a certainty that there were another international gathering at the Taj Mansingh which you were addressing, and you were chairing one very important session there, giving your words of wisdom and sharing your experience with participants from all over the world who are attending the International Bar Association event, which is being held since yesterday at the Taj Mansingh. Therefore, you were not late, sir. We are glad that you shared your words of wisdom with those people also. And as I have seen, that it is indeed a matter of great satisfaction for us that you had the taxation bench here. Aseem would definitely try to support the revenue, but I think in your hands, even the interest of the citizens would be adequately protected, as you have shown also in your orders, in your judgments, in whatever words you have shared with us. So it's a privilege to have you with us, sir. Now, with utmost pleasure, it is now time to hear our chief guest, His Lordship Justice Ujjwal Bhuiyan, who started his professional career in Guwahati, in Assam, enrolled way back in 1991, but he has had long association with income tax practice and income tax department. He was standing counsel of the income tax department for 16 years, starting as a junior standing counsel in May 1995 and subsequently appointed as senior standing counsel of the income tax department on 2008. Then designated as a senior advocate by Guwahati High Court in 2010, and he was appointed as additional Advocate General Assam in 2011. Thereafter, he was appointed as additional judge of Guwahati High Court on 17th October 2011 and transferred thereafter to Bombay High Court on 3/10/2019, all the way from Guwahati to Bombay, and then after a 2-year stint in Mumbai, Justice Bhuiyan was transferred to Telangana High Court and took oath as judge on 22/10/2021. And then he was appointed as Chief Justice of that High Court in the year 2022, and thereafter rightly elevated to the Supreme Court on 14th of July 2024. So you can see the varied experience that he had by being firstly counsel in Northeast, and thereafter being transferred from one high court to another. I don't know whether it is a good thing or a bad thing, that only the judges can say, or those who are transferred, but at least it shows that he had that sort of experience being a judge of Bombay High Court, which is the center of our financial activities there, and thereafter moving on to Telangana, you see, as a judge and becoming the Chief Justice before being elevated to the Supreme Court. So I think it's indeed a great pleasure and privilege for us to have your Lordship's presence here. So they will
Justice Yashwant Verma, Judge, High Court of Delhi, Mr. Venkatramani, Learned Attorney General for India, Dr. Lalit Bhasin, President, Society of Indian Law Firms, Dr. Manoj Kumar, Additional Secretary to the Government of India, Ministry of Law and Justice. The star of today's program, the learned author, Dr. Aseem Chawla, host of today's program, Rupali Chawla, publishers, corporate law advisor, eminent senior advocates who are present here, members of the Delhi Bar, family members of Aseem and Rupali, distinguished guests, ladies and gentlemen. A very warm and good afternoon to all of you. Before I say something on the topic which has been assigned to me, Bhasin had said about the cumbersomeness of the income tax, the act. It is indeed so. By the time you are on the 16th proviso, what was there in the first proviso you don't recollect. And it's very difficult to connect the two, not to speak about the parent section. We have been hearing so often that there would be a simplified version of the tax code, but it has not seen the light of the day. I think it is necessary because otherwise, because of the very complexity of the language itself, it has given rise to a lot of litigation, and which can be easily avoided. Dr. Bhasin has also spoken about transfer of judges. Now that I am in the Supreme Court, I can speak a little bit more openly on this subject. I won't be transferred hereafter to anywhere else. Transfer is actually, from my experience, I'll say, when I was a Chief Justice in Telangana, a lot of judges of Telangana were transferred, which created a lot of hue and cry. In fact, Telangana High Court, about 9 judges have been transferred to different high courts for various reasons, from Tripura to Patna to Karnataka to Tamil Nadu, Rajasthan also. So the lawyers had even gone on a strike. So I called them that, why are you on a strike? You are under this is not even a service. You are you are a judge of a constitutional court. You are bound to go wherever the requirement of law is. And I spoke to them and told them about my own experience. Of course, I said that transfer is necessary in the administration of justice. Transfer of judges of high courts is necessary, but certainly there is scope for improvement, and there is nothing wrong if the concerned judge is informed a little bit in advance that we are contemplating to transfer you. Please get ready. There is no harm in doing so. So one gets mentally prepared for such an event. My transfer, in fact, when I was transferred from Guwahati, I was the number 3 judge there. Unfortunately, the bar thought that by transferring me to Bombay, where I would be placed at number 15, this was some kind of a demotion. It doesn't happen that way. Your seniority is always relatable to your parent high court. But there were others also who are very good at calculating. You will find a lot of people who are most of the time, he will retire here, he will retire this, and then by the time this happens, you will be number 4th, 5th, 6th, like that. So one lawyer, he came up with a chart that this Justice Dharmadi will go here, he will go here, those so-and-so will go here, and by the time you are so-and-so, May 2025, you will be a Chief Justice of Bombay High Court. So it was very good, it's okay. So, but actually my mother was very sick. So, it was 28th of August 2019 when I got a call from the Office of the Chief Justice of India. And then I was told that it's high time you should move out of your High Court, move out of the comfort zone. I said that my mother is sick, she's almost bedridden, she's bedridden and almost on a deathbed. Please give me 2 months' time. The Chief Justice said it, all right, the Collegium will take the resolution. You make a representation, we'll certainly consider. The bar went on a protest. There were a lot of meetings, and in his own parent High Court, the bar adopted very strong resolutions, strongly worded resolutions, which perhaps was not to the liking. In fact, I got a letter from the Secretary General of the Supreme Court also, thinking that the Supreme Court has taken very strong objection to this kind of protest being organized there, and that the needle of suspicion was that it was I who had engineered such protest. So I told him that as a judge, I am bound to obey the command of the Chief Justice of India. I will go whatever. I can't control the bar. I can't tell the bar not to do this, not to do this. Who am I to say? So ultimately, I had to go there. But Bombay was an exceptional experience for me. I have no hesitation in saying, people say I was a good judge in Guwahati also. I had delivered about 16,000 judgments there. But it was Bombay's 2-year exposure, particularly I was heading the tax bench there, which transformed me from a provincial judge to an all India judge. It was then that people started noticing, and Justice Ramana came into the picture and he said, now it's time to move on to Hyderabad. So again, the judges and the lawyers were a bit upset there. Why are you going? You are doing so well here. Why are you going there? Some, in fact, thought that this was again some kind of a punishment. From Guwahati to Bombay, now Bombay is going to Hyderabad. Anyway, as luck would have it, I was there. These transfers have actually helped me in the progression of my career, if I may put it this way. Had I stayed back in Guwahati, I would have been promoted as elevated as Chief Justice only about a couple of months back only. So these transfers have in fact fast-tracked me. So be that as it may, the point is that transfers are necessary, but there is room for improvement, and transfers can be done in a much more better way with more consultation, because after all they are judges. They have their families. Now transferring from one corner to the other corner, it uproots so many things. But I still remember Justice Bobde, when he met me, he said that if you want to become a good judge or a better judge, it is advisable that you move out of your comfort zone, go to a different High Court, where there will be, without you realizing, when you are in your parent High Court, there are a lot of hidden pressures, pulls and pressures, which will not be there in a different High Court. So that's the story. Justice Gawai told me over phone that there's a very scholarly lawyer of Delhi High Court who is also a prolific writer. He is writing a book on taxation. So why don't you go there and get the book released? Then I told him, sir, why don't you do that? He said, taxation is not my cup of tea, and that I would like, and I would like to avoid that. And why don't you take over? So Aseem came, and it was a wonderful interaction we had, followed by another interaction. So it's very nice to see a fellow standing counsel like me doing so well. And standing counsel of the department doesn't mean that you only represent the stand of the department. It is much more, it goes beyond that. You have to ensure that there is no miscarriage of justice. That is your duty. I was the standing counsel for a long period. Over a period of time, the very esteemed lawyers who appeared for the SACs, we became friends. Day in and day out, we used to argue cases on the other side. As Shakespeare used to say, strive mightily, but eat and drink as friends do in law. Inside the courtroom, we will not yield an inch, but outside, we are all friends, we are all colleagues. That's the beauty of the legal profession. So I'm very happy to be present here today in this book release function of the book Play in the Joints, Text Insights, and the Play Continues. Dr. Bhasin had playfully said that pain in the joints. Often income tax is a pain, not in the joints but somewhere else. This book is a labor of love of the learned author who has taken great pains in researching through various provisions of the income tax law, including international taxation and the new reassessment regime, delving into the Prevention of Money Laundering Act, the Benami Transactions Prohibition Act, particularly the controversial 2016 amendment, the decision to go for demonetization and its after effects. He has also dealt with virtual digital assets, which are popularly known as cryptocurrency, various facets of the Goods and Services Tax, GST, and finally the future of the country as he visualizes the economic horizon of the country in 2047 on completion of 100 years of independence. The book has been divided into 6 chapters, each dealing with significant contemporary topics covering the above fields. This book reflects the hard work and scholarship of Dr. Chawla. I therefore compliment him for writing this book, which I am sure will be very useful not only to the bar and to the bench, but also to all the stakeholders. I must also thank Rupali Chawla for her contribution and support. Without her support and inspiration, I doubt whether Aseem would have been able to bring out this book. So the credit for the book must go equally to both. Both of you deserve our congratulations for this wonderful effort of yours. I also take this opportunity to compliment the publishers, Corporate Law Advisor, for publishing the book Play in the Joints, Tax Insights, and the Play Continues. Friends, like in movies, doesn't matter. Like in movies where we had a scene or behind the camera, various players whose contribution to the making of a film cannot be understated. Similarly, the role of law in the legal field cannot be ignored. Be it the profession, be it the courts, or be it the academia, law books and by extension law book publishers play a significant role. They are a vital clog in the administration of justice. Despite advancement in technology, law books are here to stay. We must acknowledge the role of law book publishers in the life of law and justice. The field of law and justice would be incomplete without the silent contribution of the law book publishers. My congratulations to Corporate Law Advisor for publishing this book. Justice Narasimha, my esteemed colleague, senior colleague in the Supreme Court, has written a very inspiring foreword to the book. Justice Verma of the Delhi High Court has also commended the author for his rigorous research and thoughtful insights in his foreword. Besides, the book also contains several congratulatory messages. Dr. Chawla is not only a lawyer, for that matter an income tax lawyer representing the revenue, but is also a serious observer of the unfolding world of taxation and commercial laws. His scholarship has found expression in several works, including the book published in the year 2021 on the Indian taxation landscape, which he has fondly titled Finding a Straight Line Between Twists and Turns. Justice Rohinton Nariman, former Judge, Supreme Court of India, has described this book as an essential read, not only for the legal practitioners, but even for a common person who wants a simple but detailed breakdown of complex tax laws resulting in litigation. Well, friends, we all know that broadly we can divide taxation into indirect and direct. Since the first war of independence, 1857, serious effort was made by the colonial government to raise revenue, and this resulted in the Comprehensive Income Tax Act of 1886, followed by 1922, and then post-independence 1961. Power to levy tax is one of the sovereign functions of the state, and in the Indian context, Article 265 of the Constitution is the flag post. No tax shall be levied or collected except by authority of law. Therefore, what Article 265 says or requires is that number one, there must be a law. Number two, the law must authorize the tax. And number three, the tax must be levied and collected according to the law. And this law must be specific. It can't be vague. For a citizen, whether he likes it or not, he has to pay the tax. Either directly, for example, as a tax on income, or indirectly on the purchase of goods and services. Taxation is an important source of revenue for a nation. It is the price that we pay for our civilization. In recent times, we have witnessed a significant rise in tax litigation. Recent data of the Central Board of Direct Taxes suggests that only 0.3% individual filed zero taxable incomes in the assessment year 23-24 in comparison to 0.7% in the assessment year 2013-14. The share of direct taxes in GDP also rose to a high of 6.64% during the financial year 2023-24. As per an article titled Litigation as a Measure of Well-Being, new evidence suggests that higher litigation rates need not necessarily be linked to an overtly litigious society or a drain on the economy. On the contrary, it can be a natural consequence of economic development and improved human well-being. However, it is equally true that increased litigation, particularly tax litigation, has resulted not only in the blockage of considerable amount of government finances, but has also clogged our court system. There can be no denial of the fact that the state is the biggest litigant in the country. In 2021, the Minister of State for Finance had informed the Rajya Sabha that as of July 29, 2021, Commissioner of Income Tax Appeals, the first appellate authority in the income tax, across the country had 4,78,606 pending appeals. Income tax appellate tribunals had 62,130 pending appeals as on 1/7/2021. The high courts were handling 26,000 odd income tax cases and 2,894 such appeals were pending before the Supreme Court. Financial Express in April 2024 has reported that the number of appeals before the Commissioner of Income Tax Appeals has grown up to 5,44,205 as of June 31, 2024, and 63,246 appeals were pending before the ITATA, High Courts and the Supreme Court. Of course, one must acknowledge the success story of the Income Tax Appellate Tribunal. When we make an audit of the success or otherwise of tribunalization in India, the one example of success story we give is that of the Income Tax Appellate Tribunal. The one tribunal which everyone agrees is a success story is the Income Tax Appellate Tribunal. Therefore, SSCs filing appeals and contesting revenue demands before the highest fact-finding body is indicative of the robustness and vibrancy of the Income Tax Appellate Tribunal. One of the reasons for high filing of appeals by the revenue before the High Courts and also before the Supreme Court is the tendency to play safe. Revenue officials tend to leave it to the court to take a decision on the stand of the revenue one way or the other, rather than taking it upon themselves so as to avoid departmental and vigilance action. Central Board of Direct Taxes has come up with various circulars from time to time, fixing monetary limits, enhancing monetary limits for filing of appeals by the revenue before the ITAT, the High Courts and the Supreme Court. This has gone a long way in reducing pendency. However, according to me, additional steps are also required to be taken to filter appeals before being filed by the revenue in the Income Tax Appellate Tribunals or before the High Courts or before the Supreme Court, so that claims which may not stand legal scrutiny are not filed before the tribunals or the courts by the revenue. Professor Rolim, a leading Brazilian tax lawyer, he has written a book on proportionality and fair taxation. He has articulated in his book about the need for a fair tax system. He says that a fair tax base is traditionally described as a matter of horizontal equity, while specification of tax rates is characterized as a question of vertical equity. Professor Rolim says that these two types of equity, horizontal equity and vertical equity, are based on the ability to pay principle. Each of the sources, such as income, consumption, wealth, taken individually or collectively, should form a fair tax base that should not be arbitrary, excessive, or confiscatory. Every taxpayer, we have come a long way since McDowell's. Every taxpayer can plan his tax. There is no wrong in it. Tax planning is legitimate and is distinguishable from tax evasion. An assessee is entitled to claim deduction, rebate, refund, or even tax exemption where these are permitted in law. But as we have seen, because of a structured administrative setup, income tax, the substantive law as well as though keep on changing with each assessment year, the procedural aspect has attained some kind of stability in the income tax department. Even the search and seizure operations under 132 has also, to a great extent, has evolved over a period of time. It is no longer what it used to be, say about 3-4 decades back. But the same thing cannot be said about indirect taxation, where the law is still evolving. After several enactments, sales tax, general sales tax and petroleum tax and so on and so forth, and after the 101st Constitution Amendment, we now have the central and state laws relating to GST. For paucity of time, it may not be possible to discuss various aspects of GST law, but there is one area or one aspect which I want to flag off, and this is relating to arrest under GST laws. Dr. Bhasin has said about the laws being very coercive, taxation laws. This one particular provision, I feel, is there in the statute book. Section 69 of the CGST Act of 2017 empowers arrest of a person, subject to, of course, the commissioner must have reasons to believe that that particular person has committed an offence under 132. Basically, it is evasion of GST, and that therefore he may, by an order, authorize any officer of central tax to arrest such a person. Now, I need not go into reasons to believe. From Calcutta discount onwards, we have come a long way. It is now, though not a defined expression under the GST laws, through judicial pronouncements, this is now a very well understood expression. Now, when I was in Bombay High Court, one case came before me. A person was arrested on the ground that he was evading payment of GST. It is Daulat Samirmal Mehta versus Union of India. And it was a petition filed under Article 226. So as usual, the revenue said that he should file a bail application. He should move the trial courts. Why under Article 226? In that case, we had dissected this provision of Section 69 and as also the reasons to believe by the Commissioner, and we have said that it not only it is limited to the person has committed the offence, alleged offence. The Commissioner must also indicate the necessity for arrest. Power to arrest is one thing, and the need and necessity to arrest is another thing. So, exercising power under 226, the division bench of the Bombay High Court granted bail. During that particular period, no High Court was granting bail to persons arrested for alleged evasion of GST. So, in this case, Bombay High Court granted bail to Daulat Samirmal Mehta under Article 226. Of course, as a measure of abundant caution, my bench had imposed certain conditions that on being, he will pay 5 crores and on being released in 30 days, he will pay another 10 crores or something. The department came up in a SLP before the Supreme Court. Luckily for the taxable person, the matter came up before a bench headed by Justice Rohington Nariman. And not only the SLP was dismissed, the 2 conditions imposed by the Bombay High Court of deposit of 5 crores and 10 crores, those were set aside. So therefore, this is one area which requires. Similarly, there is the power of provisional attachment. This is again, I feel, has been very randomly used by the authorities. These are very drastic powers and should be used only as the last option. While in Telangana, there was another matter which came up before me. Agarwal Foundries Private Limited. The investigation was going on and on. And so in that case, we had held that there can't be an endless investigation. At some point of time, the investigation must must be completed, and the demand had to be adjudicated. Before a demand could be adjudicated or quantified, it would not be, and before the assessing period was over, it would not be proper to term anybody as or accuse him of evading payment of GST for that matter. He has also written about the Benami Transactions Prohibition Act. While I was in Telangana, my bench had authored a judgment in Nexus Feeds India Limited. We had set aside we have held that the amendment of 2016, because it is substantive law, the creating an offence cannot be applied retrospectively, cannot be applied to transactions applied retrospectively. I think the department has filed SLP against that. But there's from Calcutta High Court, I think Ganpati Dilcom Private Limited, Supreme Court has also taken the same view that for transactions prior to the amendment, this amendment could not be applied. Now, I am told that very recently, a bench of the Supreme Court on 18/10/2024 has allowed a review petition by the Union of India and has recalled the decision in Ganpati Dilcom Private Limited. So, matter is again been thrown open. Anyway, he has also highlighted about the PMLA. Insofar PMLA is concerned, I am part of many benches which have passed orders on PMA, judgments and orders on PMLA. And I had also delivered a speech in Bombay while releasing a book on PMLA by advocate and solicitor Achilles Dubey. I'll come to that. No doubt money laundering is a very serious and complicated offense. It is not only multi-layered, but is also a continuing offense. Adding to the complexity, many PMLA cases have got transnational ramifications as well. Essence of money laundering is introducing crime-tainted money, which is textually referred to as proceeds of crime, into the regular economy, and in the process make such money appear as legitimate. I had released a book titled Treatise on PMLA, Law and Practice, authored by advocate and solicitor Achilles Dubey at Mumbai in March this year. While releasing the book, I had spoken extensively about various facets of PMLA. I do not want to repeat what I had already said. Suffice it to say that the law on PMLA is evolving. The last word is yet to be spoken. Very recently, a bench of the Supreme Court in Directorate of Enforcement versus Bibhu Prasad Acharya decided on day before, 6/11/2024, has declared that Section 197 of the Code of Criminal Procedure would be applicable to cases filed under the PMLA. Friends, in my Bombay speech, I had said that PMLA is a potent weapon in the fight against crime-tainted money. It is very much necessary to fight the menace of money laundering. But we all know that a weapon loses its potency if it is overexposed or over-applied or even misused. If that happens, there may be negative perception about the activities of the Enforcement Directorate and by extension PMLA, in which event it is the community and the nation which will suffer. Following my speech, the live law people came and told me that this speech has gone viral and it has crossed all the likes and all those. And the author came and met me and said that, sir, my book has become a bestseller now. I am into my third edition. I hope Dr. Chawla's book also will be a similar fate like that. Will certainly be a bestseller. So friends, all said and done, in this rapidly changing landscape of economic growth and globalization, the role of the judiciary in maintaining a balanced approach between taxpayers' expectations and the government's revenue needs is more crucial than ever. Taxation is fundamental to the state's ability to meet public needs, fund infrastructure, and deliver essential services. However, in an era marked by evolving business models, digital transactions, and complex international tax frameworks, ensuring fairness and transparency in tax laws has become increasingly challenging. The judiciary, particularly the Supreme Court, stands as a pivotal force in this dynamic, evolving scenario, tasked with safeguarding taxpayers' rights on the one hand, while respecting the government's legitimate revenue interest on the other hand. Taxpayers expect clarity, predictability, fairness, and finality in the decision making in the tax system, while the state requires the finances necessary for the nation's progress. Balancing these interests is a delicate task and requires the judiciary's principal guidance. Through judicious interpretation, constitutional scrutiny, and evolving jurisprudence, the judiciary plays a vital role in bridging taxpayers' expectations and the state's revenue imperatives. However, we must all remember, and I say this often, that rights of the assessee has to be respected. There can only be a progressive accretion to the rights, and there cannot be any rolling back or recoiling of the rights. So the role of the courts become very important in the sense that it is our bounden duty to ensure that the rights enjoyed by the citizens are in no way restricted or recoiled while the law keeps on evolving. Thank you very much for inviting me and giving me this opportunity to share a few of my random thoughts. Once again, I must thank and compliment Aseem and Rupali for their hard work in bringing out this book. I am sure there would be many more such creative endeavors in future which will benefit all of us. My best wishes to the author and to the publisher. Thank you very much and God bless.
We are very grateful to Justice Gawai for suggesting to your Lordship that you should address this gathering. We were under the impression that a judge, and particularly that of a Supreme Court or the High Court, they know everything. Because we see in the High Courts, judges who are hearing some civil matters are transferred to criminal benches, from criminal benches to labor matters to other benches. But to have this sort of expertise, the way with the authority which you spoke about, shows that expertise and knowledge does count. And your stint as the standing counsel of the Income Tax Department, I think, shows your deep involvement, your knowledge, your commitment, and profound impact you see on the income tax practice and all. You very rightly pointed out several things which I am sure if live law or bar and bench, if they are present, they would highlight. It is power to arrest is one thing, but to need to arrest, that is very important. Then your Lordship also pointed out that certain provisions of the Income Tax Act, and you refer to about numerous provisos which were added. So I also had the chance to look at, when I started my practice, at the Income Tax Act, and I came across Section 80. Now that Section 80 started with 80, then 80A, capital A, it went on to Z, then it again started with 80AA, then again went down, you see. So I say I gave up, you see. I will not practice this branch of law. And I think you spoke about the law books. I still adhere to reading the law books, holding the books in my hand. I don't know what is the future of the law publishers. If everything goes online, then we will not have these books like this, you see, which is about to be released now. And I do appeal to everyone to keep this tradition, I think, of reading books, which we all have, as preserved. Use technology or artificial intelligence as a tool of research, not as a tool to serve justice. It cannot serve justice, I tell you. It can only be used as a tool. I was sharing one head table with the Honorable Chief Justice of India, and he rightly pointed out how ease of filing filing petitions, evidence, affidavits, everything has been streamlined. Now you can address the Honorable Court by video conferencing, VCs and all sitting in Goa. You can address the Supreme Court and simultaneously address, you see, Guwahati Court and all that. You can do all that. So when my turn came to propose a vote of thanks, I say, Your Lordship is right, but what about the disposal of cases? Can it be done through AI? Because no two cases will have the same facts, same impact. You will have to use this, not the artificial. You have to use real intelligence, not AI, to resolve those cases. Therefore, something needs to be done. Given a serious thought, how technology can be used effectively, these 5 crore cases which are pending, how the pendency can be reduced. Our courts are overburdened by that. So analysis has to be done. What is the cause? And I'm glad that the government is represented here. Because as Justice Bhuyan rightly pointed out, that government is the largest litigant. They have to show the way how to reduce, you see, this pendency, how not to go at the drop of the hat. If some order goes against them, file an appeal, file a revision, file a 226 or everything, you see, that goes on. Therefore, something needs to be applied. I am very grateful to you, sir, for your very brilliant address. Thank you very much. And now, Aseem. Yeah. Now we have the book release. Request the Honorable Chief Guest and Justice Verma and Mr. Venkat Ramani, Dr. Manoj Kumar, to release the book.
Thank you.
Now over to the author. He must have the final word. A fitting finale.
Guru Nanak said, Vidya vichari ta parupakari. Nanak emphasized that if you desire to acquire true knowledge, make people welfare your aim in life, contemplate and reflect upon knowledge, and you will become benefactors to others. The presence of dignitaries on the dais and the galaxies of luminaries present here today and their gesture of sparing time is a testament to the teachings of Guru Nanak. Ladies and gentlemen, distinguished members of the bar, all of you would agree, and what Mr. Bhargav spoke a little while ago about 11 months of book and 400 pages and 6 proofs and 2000 changes. Making a zealous attempt to pen a contemporary tax piece is like an octopus on roller skates. There are plenty of movements, but you never know if it is going to be forward, backwards, or sideways. A sampler of the same is as follows. We finished the reassessment chapter entitled at that point in time New Assessment Regime. When it was about to set in print, we had the 2024 version of reassessment provisions. So now the chapter is christened as 2021 Reassessment Regime. We write a chapter on Benami, the book is minted, and my Lord Justice Bhuyan corrects aptly. Now the judgment is recalled on the premise that the unamended 1998 Benami Act provisions will not deal. My Lord Justice Verma spoke about Nestle. The MFN chapter is still holding up in the book nicely, knowing that there is a relentless pursuit and a third hearing of review is still being persisted at the instance of the taxpayer, the famous Nestle. Post completing the index, the budget came, and then came the amendments to the Finance Bill 2024. Similarly, the final word on the indirect tax GST levy on online gaming spectre is yet to be heard. Thanks to US elections, the international tax global reforms on global minimum tax Pillar 1 and Pillar 2, which my Lord Justice Verma alluded, are in hiatus, and the cautious approach of Indian revenue. Otherwise, the impending rewriting of rules of international tax would have further stirred the present overflow. The book is a menial attempt of presenting some expressions and reflections on prominent tax and fiscal policy themes which have held center stage in the present times. Of course, as a minion officer of the Honorable Court and bestowed with the equal honor of assisting the Exchequer, I am sanguine the book reflects or attempts to present a balanced view rather than the usual syntax of writings, more so in the Indian context where revenue is always wronged or is manifested pursuing the wrong end. In the present times, when we are witnessing overdrive or perceived overdrive of reforms, and when the contemplated form of interaction with the revenue at large is faceless, asynchronous, whether one would be able to check the box of conception of justice according to the canons of law, and whether the realization of following will happen in an asynchronous form, which is the faceless form, whether the following would happen, and this is some food for thought for Dr. Manoj Kumar also. Substantive justice, which is fair decision, procedural justice, which is fair process, open justice, which is transparent, distributive justice, which is accessible to all, proportionate justice, which is approximately balanced. I am grateful to Honorable Justice Bhuiyan for unhesitantly agreeing not only to grace the occasion but equally consenting to deliver a theme address on a topic which is close to heart of very many. More so in the backdrop of recent statement made by North Bloc advocating and making a pitch of responsible capitalism. My Lord was standing counsel for Tax Department for 16 years. His inclination in espousing the cause of knowledge is best epitomized by the fact that he continues to be the member of National Law School, Bangalore, and Maharashtra National Law University, Aurangabad. I am deeply obliged to revered Venkat Ramani Sahib, Honorable Attorney General for India, for delivering the keynote speech. Honorable Venkat Ramani Sahib's elegance can be best summed up only in one sentence. Simplicity is the ultimate form of sophistication. Honorable Justice Yashwant Verma sir, with humility, a veritable polymath. One of his recent seminal judgments, rather best described expository on international tax, was chosen as a leading judgment for deliberation at the recently concluded International Tax Symposium at the Annual World Congress of International Bar Association, Mexico 2024. Bloomsbury has reported the judgment as, and I quote, Indian court ruling provides certainty for tax treaty. I was one of the elusive tax lawyers on a side note who was asked to speak at the Mexico conference. However, due to my present call of duty, I could not participate, but I can tell you the judgment was resonating all across the corridors in the symposium. Dr. Manoj Kumar's insightful knowledge of public policy and expertise in legislative drafting must have brought a fresh pair of eyes within the legislative department and its ecosystem. Dr. Bhasin has been very charitable in supporting all adventures of mine over these years. Your enthusiasm, sir, is a tribute to your unflinching commitment to support lawyers like yours truly, who look forward to finding their own terra firma. About 12 years ago, The Week magazine did a special coverage of young lawyers. I mean, I was fairly young at that point in time. And the caption of that special coverage was, "Sparkle without an uncle." I am equally grateful for the benevolent forward and testimonials received and the generous words of appreciation from those who have achieved the upper echelons both within and outside the country. I am grateful to my colleagues at Chamber, Pratishtha and her team, my family, my father Sahib, Rupali, for their unflinching support in allowing me to pursue my travels more often at the expense of family and office supervisory time. The publisher, Shri Manoj Bhargav, acceding to publish the book. I am grateful to Team CLA for their patience in taking in stride last-minute amendments at more than one instance. I mean, you heard I've had about 2,000 all changes. A big thank you to Ratna Desai for always creating the magic with her design and the aesthetic sensibilities which she brings insofar as the designing aspect and the program. Pallavi Saluja and the extremely dependable, Dr. Bhasin did mention a little while ago, I should have briefed him earlier. Pallavi and her extremely dependable bar and bench for coming forward and supporting our pursuits and live streaming today's event. Thank you to members of print and electronic media. I'm told they are present here. In the penultimate, much like the great late J.R.D. Tata once said, I do not want India to be an economic superpower. I want India to be a happy country. Apart from what is being reported recently, the upward trajectory of tax GDP ratio India should rather have happy taxpayers. I feel humbled and do express my gratitude to all present distinguished members here in the audience, especially those who have braved late evening, early morning, connecting flights, have traveled from far off places and spared their time in coming down to Delhi. I started with Nanak, so I shall conclude with the rendition of Guru Nanak. Quote, burn worldly love, rub the ashes, make ink of it, make the heart the pen, the intellect the writer, write that which has no end or limit. Unquote. With this, as a servile follower of the subject, I commend this abject work in the profound memory of my late mother, Phul Subhash Chawla, who despite her modest background and upbringing, always imbibed us the lesson that purpose of life is not lost in its trivialities. मुझे तोड़ लेना वन माली, उस पथ पर देना तुम फेंक, मातृभूमि पर शीश चढ़ाने जिस पर जावें वीर अनेक. Thank you for your time. We have some pleasantries to be done. I would just request my father, Chawla Sahab, to come over. With this, I commend this book, to all here present and to all. Please appraise it, give your comment and your feedback, and hopefully it stays relevant considering the spate of amendments, etc.
It is already a bestseller. You better prepare for the second edition.
Thank you. Yeah. Right. Okay. Can you please come over the DS, please? Justice Bhuyan, please. Mr. Venkat. Justice Verma sahab. Dr. Manoj Kumar. Lalit ji. Lalit ji. Lalit. For Justice Bhuyan. Venkat Ramani sir. Sure. Dr. Basim. Dr. Basim. Justice Verma. Manoj. Dr. Manoj. Dr. Bhasin has already made the sales pitch. Otherwise, I would have said that, well, proceeds of all honorarium literary work. Sorry. Dr. Bhasin has already made the sales pitch. Otherwise, I would have said all honorariums, literary work contributions, and all proceeds of past books, publications goes towards augmenting the cause of education by a trust which our family runs, Sukhmani Parivar Trust. We are supporting a couple of private tutorials. So, but that pitch has already been done. So, before we draw curtains, all of us agree that we stand here with and there are a lot of heavenly blessings which are bestowed up from the heavens. Some of our elders, family members, or the ones whom we cherished most are no longer with us, but their blessings, and we bask in the sunshine of glory of their blessings. In the memory of two angels also who are besides our side, before we draw curtains, may I quickly request if we can play Shanti part, please.
द्यौः शान्तिः अन्तरिक्ष शान्तिः पृथिवी शान्तिः आपः शान्तिः ओषधयः शान्तिः वनस्पतयः शान्तिः विश्वे देवाः शान्तिः कामः शान्तिः क्रोधः शान्तिः ब्रह्म शान्तिः सर्वः शान्तिः शान्तिरेव शान्तिः सामः शान्तिरेधि यतो यत समीहसे ततो नो अभयं कुरु शन्नः कुरु प्रजाभ्यो भयन्न पशुभ्यः सुशान्तिर्भवतु सुशान्तिर्भवतु सुशान्तिर्भवतु.
Please join us for high tea. Thank you once again. Thank you for your presence.